Hi guys, this is Samuel Odhiambo, a senior law student at JKUAT, current campus, Nairobi, Kenya. I would hereby once again like to welcome you all to the Samuel Law Podcast and Academy YouTube practice so that together we can get to learn more about our laws. Please welcome. So today, we are still going to look at the tort law, and in our second lesson, we are going to look at the element of negligence. Our objective today, we are going to define what negligence is. We are also going to identify the basic elements of negligence, understand the duty of care and its breaches, and also get to learn about causation and remoteness of damage. And finally, we'll also get to learn about the defenses applicable in the tort of negligence. So let's begin with our introduction. What is negligence? Negligence is actually the most important tort in modern law, as it concerns a breach of a legal duty to take care, with the result that a damage is caused to the claimant. It is considered as one of the most important torts in modern law, as it protects against three different types of basic or common harms, which are personal injury, damage to property, and economic loss. So what are the elements of negligence? It has three main elements, which are 1. A duty of care, 2. Breach of the duty, and then 3. Damage caused by that breach. So let's look at them one by one so as to get to know what they entail. Let's begin with duty of care. Duty of care is a legal concept which outlines the circumstances in which one party can be liable to another in negligence. And the main test currently used for a duty of care is the Caparo test, which brings to the fore the following questions. Is the damage reasonably foreseeable? That's question number 1. Number 2, was there a relationship of proximity between claimant and defendant? And then number 3, is it just and reasonable to impose a duty of care? Over the years, the test has been modified for cases which involve economic loss, psychiatric injury, omissions, acts of third parties, special groups, and many others. So let's get to look at them one by one, and we'll begin with duty of care, economic loss. The duty of care test used for cases involving pure economic loss is one which requires 1. A special relationship between the parties, 2. A voluntary assumption of responsibility by the defendant, 3. Reliance on that advice, and finally, that it was reasonable to rely on the advice. And what are some of the disadvantages of the law on economic loss? We have too few or too many restrictions. There is overlap with contract law, lack of clarity, being number 3. Let's now look at the duty of care, psychiatric injury. The duty of care test for psychiatric injury cases involving primary victims contain 2 elements, and these are 1. Is there a recognized psychiatric injury? And then number 2, was the claimant injured both physically and psychiatrically, or was he in a danger of physical injury? Under the normal rules of negligence, these two types of claimants can make a claim, unlike for a secondary victim, that is one who is a witness to the incident but not in any physical harm personally, where further tests are applied. Do they have a recognized psychiatric illness caused by a sudden shock? Are they within a class of people allowed by law to claim compensation for psychiatric injury as a secondary victims? And then finally, what was their proximity to the shocking event? Duty of care, omissions. Generally, negligence always imposes liability for things that people do and not for those that they fail to do. However, there are instances where a defendant may be liable for an omission to act, which include, number one, where the defendant has a high degree of control over the claimant. Number two, where the defendant has assumed responsibility for the claimant in some way. And then number three, where the defendant has failed to deal with a dangerous situation that he himself has created. Now let's look at the acts of third parties. Liability is only imposed by negligence on the persons who cause damage. But there are some different circumstances where one may be held liable for others' damages or damages caused by others. And these include vicarious liability. Number two, where there is a relationship of proximity between claimant and defendant. Three, where the same relationship exists between the defendant and the party causing the damage. That's the tortfeasor. And where the defendant creates a source of danger negligently. And finally, where the defendant knew or had reason to believe that a third party was creating a risk on their property. Duty of care, special groups. Although the Caparo test still remains the basis of liability, there are a number of special groups owing a duty of care in negligence which have been subjected to special rules. And they include the police, other emergency services, the armed forces, and even local authorities and public bodies. So after looking at the duty of care, let's now look at the breach of duty of care, which is the number 2 element that we saw above. So we shall begin by defining what breach is. And breach simply means doing something that a prudent or reasonable person would not do, or not doing something that he would do. A breach of duty therefore occurs whenever a defendant's behavior falls below the standard of care appropriate to the particular duty owed. And the test used here is an objective one, which is also known as the reasonable man test, or simply as the standard of reasonableness. The test requires the defendant to take reasonable precautions and not necessarily to eliminate every possible risk, which is surely a Herculean task for anybody. What are some of the factors determining the standard of care? There are a number of factors that courts do consider in deciding on the standard to be expected of the reasonable person in the circumstances of a case, and they include: number 1, we have special characteristics of the defendant. 2, special characteristics of the claimant, the size or magnitude of the risk, how far it was practical to protect against the risk. We also have common practice in the relevant field, and then how obvious the risk is, and any potential benefits to society that might be gained from taking that risk. So let's now look at the third element, which is damage. Liability will only befall the defendant if his negligence causes damage. And the usual damages are personal injury, damage to property, and economic loss, just as we saw above. Let's look at the remoteness of damage. So the test of remoteness in negligence is reasonable foreseeability. And that is, was the kind of damage suffered reasonably foreseeable at the time the duty was breached? If the answer to this question is yes, then it does not matter that the type of damage is more serious than the defendant could have foreseen. Proving negligence. In order to fix liability firmly on the defendant, the claimant must prove that the defendant's negligence is not too remote from the damage caused. The claimant can only be relieved of this burden of proof where the defendant has a criminal conviction based on the same facts, and number two, the principle of res ipsa liquitur applies. Causation. Once duty and its breach are shown to have taken place, now it's the duty of the claimant to prove that the defendant's act or omission actually caused the damage. And the basic test is the but-for test. That is, would the damage have happened if the defendant had not been negligent? Or simply put, would the damage would not have happened but for the defendant's negligence? That's the basic test that applies here under causation. The rules on causation apply to all torts requiring proof of damage, but more complex rules apply in cases where, one, the damage has multiple causes, there are multiple tortfeasors, the negligence causes loss of chance, and also where there is an intervening event after the negligence which contributes to the damage. So what are some of the defenses? The main defenses here are: one, contributory negligence, which applies when the claimant shares part of the blame for the damage or its extent. Number two, we have volenti, and this applies when the claimant has consented to the acts of the defendant. Three, illegality. This applies where the claimant's case is connected with his own criminal act. And then number four, we have statutory authority, which applies where a statute entitles the defendant to something which would normally be a tort. So let's come to a conclusion today. And we conclude by saying, one of the reasons why negligence dominates the modern law of tort is its great appeal and potential broad application of the fault principle on which it is based. That is the fault principle which we learned in our first lesson. Liability lies on showing that the defendant's conduct has fallen short of an objective standard under this principle. The negative implication of the fault principle or negligence standard is that there is no liability without fault, as we all know. But the standard does not require personal fault in the fullest sense, as no objective standard are varied to fit the particular abilities of defendants. The positive implication on the other hand is that where there is faulty conduct which foreseeably causes damage, the defendant ought to make good the damage caused. This aspect creates an almost limitless liability, which is then rescued by the duty of care that limits the reach of the tort of negligence. There will be liability only if the tortfeasor breached a duty of care owed to the claimant. Very important. So now let's have a recap of what we've just learned today. So in this module, we've been able to learn about the meaning of negligence. We've also defined and understood the different elements of negligence. We've been able to learn about the duty of care and its breaches. And we've also learned about factors that determine the standard of care. We've learned about damage and its remoteness, also about causation, and we've also been able to understand the differences that are applicable in negligence. Thank you very much, guys, for being with me patiently. Please, let's meet in our next module where we shall try to analyze tort further by looking at all its elements one by one. I welcome you all. Thank you very much.